by our resource persons as well. In 2002, the state of Tamil Nadu passed its own version of the anti-conversion law. However, they had to repeal it later amidst widespread protest. Subsequently, in 2017, Jharkhand became the sixth state to have promulgated the Dharam Swatantra Adhiniyam of 2017. Since 2018, what we have seen is that a newer version of this law has been promulgated, wherein conversion for the purposes of marriage alone is also considered as illegal and attracts various punishments. In 2018, we've seen laws in Uttarakhand which have severe punishments ranging from 5 and in fact to 10 years in certain cases. So the Uttarakhand government was the first government which actually included conversion for the purposes of marriage alone also illegal and prohibited this under the law. Subsequently, in 2019, the Himachal Pradesh government repealed the previous 2006 Act and reenacted a 2019 law, and very surprisingly reintroduced the same provisions which were actually struck down by the Honorable High Court. And this was then followed by the Uttar Pradesh government bringing an ordinance in 2020, which later became a law when it passed when it was passed in the Legislative Assembly in 2021. The Madhya Pradesh government also did something similar. They repealed the 1968 law and passed a newer version of their law. The Gujarat government in June 2021 also brought about an amendment in their Religious Freedom Act. Then what we've seen very recently is that the Haryana government has also passed the bill, and it is waiting the assent of the Honorable Governor of Haryana. And the Karnataka government has been the recent government which have taken the ordinance route again and brought its own version of the anti-conversion law. So this was the brief history about the laws and how they have actually come into existence over the period of post-independence. And but I would like to briefly tell you that what these laws actually talk about. So broadly, if you classify, there are two major provisions that these acts entail. So the number one aspect is that no person shall convert or attempt to convert, either directly or indirectly, any person from one religion to any other by the use of force, allurement, or fraudulent means, or marriage, and nor shall any person abet such conversion. So there is a prohibition on these kind of conversions, and they are being termed as illegal conversions. So some of the definitions which are force would literally mean that if I were to use weapon and ask you to follow a particular religion, then that would be an offense that I would commit. But certain definitions under this act also include the threat of divine displeasure. So if I were to say that you may not attain salvation if you follow a particular religion, even that could be classified as force. Likewise, allurement also includes better lifestyle. So if I were to say that following this religion will actually enable you to be a better citizen, a better person, so even that can be categorized as allurement and illegal under the definition of the anti-conversion laws. The second aspect, and the more important aspect which these laws cover, is the aspect of taking prior permission before any sort of conversion. So the person who is conducting a religious ceremony, and in fact, even the person who is undergoing a conversion, they have to take prior permission from the district authority. Now, the district authority in most cases is the district magistrate of that particular area. And the district magistrate must conduct an inquiry whether the conversion is in violation of any of the laws, which is whether the conversion is brought about by force, whether it has been brought about by allurement, inducement, or by marriage. So the district magistrate authorizes the local police to conduct an inquiry about such conversions. But the problem with that is that usually the district magistrate carries a proper notice in its office, where the details, the private personal details of the person intending to convert is actually publicly displayed, and it becomes known to a lot of people who would oppose such an act. So there is this large presumption that these governments have that all religious conversions that are happening in the state are basically illegal, and therefore to keep a check on them, everybody, even if conversion is brought about by voluntary means, and if the person has absolutely no reason to oppose it, so even then those conversions are also presumed to be illegal, and therefore this entire procedure of applying for permission before the district magistrate is featured in these laws. The recent Karnataka law, in fact, additionally to the district magistrate, also requires that the person intending to convert has to inform his or her employer, and if this person is a student, then the college authorities, anybody who is superior to him in that sense. So even those details have to be those details have to be given to the people who have hired them. So that is something which the Karnataka law, in a way, goes further ahead apart from these laws. So these are the basic tenets of the anti-conversion laws, and I believe these laws are unconstitutional because they strike at the heart of the privacy of a citizen of India. There are judgments in light of the recent Puttaswamy judgment in 2017, and even the Himachal Pradesh High Court judgment, which strictly speak that the autonomy of an individual is to be respected, and the state must not care about what religion one has to follow and the choices that they make. So that is all from my end. Over to you, Lija. Thank you.
Thank you, Jevant. Before we move ahead, this is an important announcement for the participants. Below, you will see a Q&A tab where you can put up your questions or queries or doubts. And these questions will be taken up in the last Q&A session after the speakers have already finished their session. Please remember that the questions in the chat box will not be taken. You have to specifically put it in the Q&A session, and only those questions would be taken up. Moving on, now I would like to introduce our distinguished speaker. Professor Dr. Mohsin Alambat is a professor and executive director of the Center for Public Interest Law at the Jindal Global Law School. He read law at Nalsa University of Law, Hyderabad, before completing his LLM and JSD from Yale Law School. Before going to Yale, he clerked with Chief Justice P. Sadasivan, Supreme Court of India. His areas of research include constitutional law and theory, religious freedom and minority rights, law and social movements. His most recent publications are on hate crimes and on constitutional aspects of citizenship and nationality. He is the recipient of a number of awards, including the Yale University's Gruber Fellowship in Global Justice and Women's Rights in 2016, and the New Indian Foundation Fellowship in 2021. He is the co-founder of Parichay, a legal aid project for persons facing citizenship deprivation in Assam, and is on the editorial board of the Civil Liberties Media website, Article 40. Over to you, sir. Thank you so much for being with us to enrich us with your knowledge.
Thank you so much, Lija, and through you, thanks to all the friends and colleagues at ADF India for this really important conversation. And in many ways, these laws and this conversation around these laws is quite distressing, because in my own assessment, and I'm sure many of us share this assessment, these laws have not only basically been violating the fundamental rights of Indian citizens for a number of decades, but that has not even stopped a number of states from making these laws stricter and even more flagrant violations of our fundamental rights. So it's a very timely discussion, and hopefully we'll be able to move forward with it. What I wanted to do today was to give all the participants and all the audience members a sense of the key constitutional issues that are at stake here. And Jayavant has given a really helpful outline of what these laws are really about, what is the architecture of these laws, then the language. So I will take advantage of his presentation and sort of take that conversation forward. And the main argument that I wanted to put forward was that in 1968, the Indian Supreme Court did get an opportunity to consider the constitutionality of these laws in the Stanislaus case. And Chief Justice Ray's opinion, it's a very short opinion, and in fact, it is easily available online. I would encourage people to take a look at it. It's quite an easy read. And what Chief Justice Ray did in 1968 was in Stanislaus to uphold these laws, to say that the first generation of these laws by Madhya Pradesh and Orissa were constitutional. Now, it's been five, maybe a bit more decades since 1968. And my proposition is that whether or not we feel that in 1968 the Stanislaus judgment was correct or incorrect, at that time, the judgment has become completely and absolutely outdated in light of 5 decades of the evolution of Indian constitutional law, and also whatever now we have come to know about how these laws are actually implemented on the ground and how they are interpreted by police authorities in particular, but also by courts. And the reason why I want to emphasize on this argument is that there is a tremendous need now to go back to the court and make a very clear and cogent constitutional argument about why, even though when in 1968 the Supreme Court had upheld these laws, that judgment is just not valid in current legal, institutional, and constitutional legal, particularly constitutional jurisprudential sense anymore. And what I'll do is focus on 4 aspects of our constitutional rights. I'll start with the question of religious liberty and religious freedom, then move on to the question of equal protection and arbitrariness, then move on to the right to privacy, which Jayavant also quickly mentioned, and finally the right against discrimination, both caste and religious discrimination and gender discrimination as well. And obviously, by the very nature of this presentation, it has to be quite broad, but very happy to go into further details during the discussion time. So first, let's start with what Stanislaus really said in 1968. And these first set of laws, which went before the Supreme Court, and Chief Justice Ray basically said that the reason why these laws are constitutional is because the word propagation under Article 25 does not include the right to convert other people, or does not include the right to proselytize other people. And the reason why this particular reasoning was given by the Supreme Court was that under Article 25 of the Indian Constitution, the right includes right to belief and practice and right to propagate one's religion. And when people challenged these laws in 1968, they basically said that these laws are violating our freedom of religion, understandably. But what was very odd about the Supreme Court ruling on this was that nobody in that case was arguing that anybody had a right to forcibly convert other people. The question was not whether I could make somebody become a Christian or a Muslim or a Hindu. The question over there was whether somebody could peacefully propagate one's religion with the aim of eventually converting other people to, in other words, peaceful persuasion of other people. And the remarkable thing about this judgment is that the Supreme Court did not even consider why peaceful propagation for the ultimate purpose of peacefully converting people, persuading people into your religion is a bad idea. So the obsession of the court, if you just look at the judgment, the only orientation, the only framing of the Supreme Court was to look at the question of religious conversion from the point of view of the missionary, but not from the point of view of the person who wanted to convert herself. And therefore, the whole debate since Stanislaus until now has been, from in a constitutional sense, has been about what is the meaning of propagation. Does propagation include proselytization? Does propagation include missionary activity? But in my view, that is a complete mistake, because that is not the only side of this debate. The other side of the debate is what is the impact of these laws not on the person who's persuading others, but on the person who is meant to be persuaded. What about the person who wishes to convert? In other words, what is the impact of these laws on the religious choice of people to choose any faith they want to practice? And it seems quite commonsensical, right? That this should be a way in which we evaluate these laws. But if you look at the Standards Law's judgment, the Supreme Court does not even consider what the impact of these anti-conversion laws is on the right of a person under Article 25 to exercise religious choice. Um, Now, why is that the case? We first quickly need to understand why is it that the Supreme Court did not even look at it at that time. And in my view, the reason is that these laws, particularly in the beginning in 1968, that whole generation of legislations, really were born out of this obsession or even paranoia towards missionary activity. Uh, Most of you may already know that the deep worry was about mass conversions that were happening, and this belief, arguably a conspiracy theory, that there was money coming in from abroad and trying to convert the tribal communities and the Dalit communities en masse to Christianity. And this is what Jayant also pointed out, that the basis of these laws in 1960s was this Niyogi Committee report. And when you look at the text of this Niyogi Committee report, you'll see that it is writ large with this paranoia around mass conversion of subordinate communities in the country, which is without any evidence whatsoever. And it is because these laws are based on that paranoia of the missionary, ultimately what the Supreme Court did was to also frame the legal issues at play only from the perspective of the missionary or the proselytizing activity, rather than from the perspective of the citizen who has to decide or who wants to decide to change one's religious practice or faith or name or whatever, which obviously is a right which is guaranteed under Article 25. The other important thing to remember is that how these laws are by and large framed. These laws usually explicitly only say that we are not regulating a person's decision to convert herself. We are just regulating the missionary who is converting other people. But again, what we need to ask from a constitutional point of view is that even if the laws may have been framed in order to seem as if they are regulating only the missionary, what is the impact on the religious choice of a citizen in as far as their own religious identity or their own religious conviction of faith is concerned? And that is one of the major missing points in the Standards Law's case, and that is why it has to be reconsidered. Now, what are when we shift our perspective from the missionary to the believer, what we'll discover is that these laws violate a range of fundamental rights of the citizen. The most obvious and sort of on the face of it, the most patent violation was in fact pointed out ages ago by a number of constitutional scholars in India. Say, for example, one of the most foremost constitutional scholars, S.M. Sirvai, he argued in his constitutional commentaries right in the beginning that part and parcel of freedom of religion and freedom of religious autonomy and liberty is to not only be able to change one's own religious practice, but also be aware of what are the range of spiritual choices that are available, so to say, in the marketplace of religion, so the marketplace of spirituality. If I do not know what is available, what are the different spiritual practices, perspectives, metaphysical views that are available, I will not be in a position to even make a meaningful choice about what kind of religion or what kind of spiritual outlook I should adopt. It's very similar to how we understand in today's parlance. That may not have existed in 1968, but in today's constitutional parlance, we are well aware that people have not only a fundamental right to speak, freedom of speech under Article 19, we also have a fundamental right of information, a fundamental right to know, which is also part of Article 19. And Supreme Court has in fact protected it. So Sirvai's argument, in my view, updated to the present time, is exactly that. Not only does a person have a right to speak and propagate and persuade other people, but people also have a right to have the knowledge or the information about what kind of spiritual outlooks are available in, let me sort of put it loosely, in the marketplace of spirituality, in the marketplace of religious ideas. And in that sense, These laws violate Article 25 from this perspective. They also obviously violate Article 19, the spirit of Article 19 of both speaking and hearing and being knowledgeable about our social mores. Now, let me move on to the second right in question. That is right against arbitrariness. Now, constitutional right against arbitrariness is protected under Article 14 of the Constitution. If you look at Article 14, it says that everybody has a right to equal protection of laws. And the Indian Supreme Court over the last 7 or decades has included within it the right against arbitrary state action. And there are at least two interconnected ways in which these laws are absolutely arbitrary. They violate Article 14. Again, something which the Supreme Court in 1968 in the Stanislaus case just did not consider. The first is the language of these laws and the words and the definitions, which are, as Jayant also pointed out, are absolutely vague and have indeterminate meaning. Let me pick up the UP Act, the recent Uttar Pradesh Act, which I think is in many ways a culmination of these laws and its most pernicious culmination. And so most of the examples I'll give for sort of an easier accessibility of my arguments will be from the UP Act. So let's look at Section 2 of the UP Act. This is the Uttar Pradesh Prohibition of Unlawful Conversion of Religious Act 2021. And Section 2 defines all these different phrases. What was initially pointed out, that any conversion by force or fraudulent means or coercion, etc., is prohibited. So how are these words defined? Let's take the first word, allurement, because conversion by allurement is prohibited under this act. And bear with me, let me just read out. And what I wanted to point out is how absolutely vague and indeterminate these terms are. Allurement has been defined under the act as any gift, gratification, easy money, or material benefit, either in cash or kind. All right. Second, employment, free education in a reputed school. Okay. Or notice this, better lifestyle, divine displeasure, or otherwise. In other words, allurement is not only giving of money or giving of jobs, any material, tangible good, but also intangible, including spiritual assessment. For example, divine displeasure. I have no idea how any kind of peaceful persuasion of religion can happen without some invocation of divine displeasure. But even if it's not divine displeasure, think about better lifestyle. How can anybody have any meaningful conversation about a change of one's spiritual attitude or religious identity without some reference to what betterment that conversion or that change, exercise a religious choice, can have on better lifestyle? And better lifestyle need not only be material according to this definition, it could be intangible. I could just say that, well, somebody said that your life will become better, it will be more fulfilling, you will leave bad habits, and therefore you must adopt this religious lifestyle or religious choice, will also come under the definition of allurement. Or for example, take for instance coercion. Right? Coercion has been defined under this act, again under Section 2, as compelling an individual to act against his or her will by the use of psychological pressure or physical force causing bodily injury or threat. Again, what we see here is that it is not only material, obvious, physical components, which nobody in this debate is defending. Nobody on any side is saying that forcible conversion of anybody is constitutionally legitimate. The only question is, what about non-forcible, peaceful persuasion? And here what we have is, within the concept of coercion, is psychological pressure, which can practically mean anything. And these laws, not just the UP law, but all these laws are writ large with these concepts and these definitions, which are absolutely vague and indeterminate. Now, the Indian Supreme Court and our evolving vague and indeterminate concepts, particularly which criminalize behavior, which otherwise is completely legal, are unconstitutional. The most sort of famous endorsement of this principle was in the famous Supreme Court judgment in Navtej Johar around the Section 377 provision. And there the Supreme Court and practically all judges said that vague and indeterminate clauses which criminalize legitimate, reasonable exercise of freedom is unconstitutional. Again, this is recent position. Arguably, in 1968, the Supreme Court had not laid down these norms, but clearly it shows that the Supreme Court ruling in 1968 is completely outdated and conflicts with how we understand our Constitution today. But I think a stronger argument, which is in a way related to vague and indeterminate definitions, is another very important concept that the Indian Supreme Court has started using in our fundamental rights jurisprudence. And this concept is called the chilling effect doctrine. The most interesting and important expression of the chilling effect doctrine was in the famous 2015 judgment of Shreya Singhal. And some of you may remember this case involved Section 66A of the IT Act. And what Section 66A said was that under the IT Act, it criminalized or prohibited passing on of information, and the language of the act was. And the reason I'm reading this out is I want you to note the similarity between what the Supreme Court was dealing with in the IT Act case and what we are looking at now in these anti-conversion laws. In the IT Act, Section 66A said information that is grossly offensive and has menacing character. That was a language which was used under the IT Act. And this was punished, right? If anybody passed on information that was grossly offensive, quote unquote, or had menacing character, quote unquote. This is what, let me just read out this part. This is what Justice Nariman said. Justice Nariman ruled, and I'm quoting him, that this language, to quote him, takes within its sweep protected speech and speech that is innocent in character and is liable, therefore, to be used in such a way as to have a chilling effect on free speech, which in other words means chilling effect is when a particular provision of law excessively includes not only things that we want to prohibit, but also things that we should not prohibit because they are legitimate, reasonable exercise of freedom. What happens is that even that legitimate exercise of freedom starts to get encumbered or limited or harmed. It has a chilling effect on legitimate exercise of your liberty or your fundamental rights. Let me quote another sentence from Justice Nariman. He says Section 66A is cast so widely that virtually any opinion on any subject would be covered by it, as any serious opinion dissenting with the mores of the day would be caught within the net, right? So even if I may say anything, anybody can find anything grossly offensive, and therefore it would come under 66A. And therefore my freedom of speech is restricted. It has a chilling effect on my freedom of speech. Then Justice Nariman says, such is the reach of the section, and if it is to withstand the test of constitutionality, the chilling effect on free speech would be total. The reason I read out this portion is that there is no distinction. In fact, anti-conversion laws are even a worse version of what we saw in 66A. So if the Supreme Court rules that in the case of 66A, where phrases like menacing character or grossly offensive are considered to have a chilling effect on the legitimate exercise of the fundamental right to freedom of speech, there is absolutely no doubt in my mind that using languages like divine displeasure or better lifestyle or otherwise, these are the words that are used in these anti-conversion laws on exactly the same grounds are completely unconstitutional. Why? Because they have a chilling effect, considering that they are vague, they are over-inclusive, they are not specific, they are indeterminate. They have a chilling effect on very legitimate, constitutionally protected fundamental right of freedom of religion, freedom of religious practice and belief. And therefore that gives the most sort of clear-cut ground of why Stanislaus should not only be reconsidered at this stage, but in many ways is fundamentally incompatible with the Constitution. Now, moving on to the next important fundamental right. Again, something that did not exist in 1968, but is now considered to be the central feature of India's fundamental rights jurisprudence. That's the constitutional right to privacy. And we know that the Supreme Court in 2017 in the Puttaswamy case and subsequently in Puttaswamy 2 very categorically said that the Constitution protects, as a matter of autonomy, liberty, and dignity, and right to life, the constitutional right of privacy. Um, and what these laws do, and some of these provisions which Jayant also read out, and I'll repeat that. What these laws do, in my submission, both directly and indirectly violate the constitutional right to privacy. They are flagrant violations of constitutional right to privacy. They do it directly, indirectly, in two ways, right? So one way in which they do it directly is, or indirectly, is by asking people who are converting, right? So maybe the missionary or the priest or the Maulana or the Pandit, whoever, to go to the government and register the conversion before, or give a notice or declare that a conversion must happen. If you look at Section 8 of the UP Act, for instance, and you can make a note of it and take a look at it and look at the language that is being used. So one kind of notice or declaration obligations under many of these acts are placed on the person converting others. And many of these acts, including Section 8 of the UP Act, places these notice and declaration requirements on the person who wants to convert herself. So both directly and indirectly, there are these notice and declaration requirements, which are meant to make a person, whether converting or who's converting herself, to tell the government and put up a notice and tell the whole world that they are converting, or they have decided to exercise their constitutional right of religious choice. And these particular regimes completely violate what the Supreme Court in Puttaswamy had held. Now, let me sort of go step by step about why I believe that is the case. The first step when we do any analysis of constitutional privacy, particularly in light of what the Supreme Court has said, is first to see whether a citizen or a person has what the Supreme Court has called a reasonable expectation of privacy in that particular field. Right? So the idea is that first we need to make the assessment of whether the activity that is being regulated, whether a person can reasonably say that I should be allowed to exercise uh, a right to privacy here. This is a private activity, right? So, for example, my sexuality, for example, is a great case of that, simply because Puttaswamy explicitly mentions that it is part of my identity, it is part of my personal moorings, it is my choice, it's my private business, it's nobody else's, and therefore it is protected by, one can have a reasonable expectation that it is protected by the constitutional right to privacy. And it is absolutely undeniable that one's religious faith, one's religious conviction and religious identity is completely covered by reasonable expectation of privacy. In fact, religious identity in most fundamental of ways is connected to our personal identity, and our personality, as Puttaswamy judges put it. And therefore, there's no question, one has a reasonable expectation. But one must move on to the next question, because even when a person has a reasonable expectation of privacy, the state can still say that we can still regulate or still place reasonable restrictions on your right to privacy. And therefore, the real question constitutionally we need to ask is the state right or justified in restricting my right to privacy when it comes to my religious identity by forcing me directly to either declare that I'm converting, or forcing other people to declare that I'm converting. Ultimately, it is my privacy that is being violated, whether they are making me do it or making somebody else do it. It is my privacy that is being violated. And what the Supreme Court in Puttaswamy clearly held was that when we are making this analysis, that is it justified restriction on somebody's privacy, we need to adopt proportionality. We need to balance whether there is a good balance, a proportional balance between what the state legitimately wants to achieve and the cost it may have on my rights, on my right to autonomy and dignity and privacy. So there always has to be some kind of balancing, which is completely acceptable. Now, the reason I'm spending so much time on this is because if and when this issue goes back to the Supreme Court, this is exactly what the Supreme Court will have to do. So what will the government argue? Let me be very generous. The ostensible defense of the UP government, for instance, would be that the reason we want these notice requirements and declaration requirements is because we want to ensure that no conversion in our state happens which is forced and coerced. And therefore, what we do is we ask people to come and report to us so that we make sure we are convinced that there is no coercion. In my assessment, this is a completely disproportionate way in which the state can assess. And arguably, the state is legitimately can legitimately say that we don't want anybody to be forced to be converted. But in my view, this is a disproportionate way of doing it. Think about it, just to be slightly provocative. Let me give you an analogy. Suppose the state wants to make sure that because in our society there's so much sexual violence and rape and other things, it wants to ensure that women are not coerced and coerced into sexual relationships, which is a very legitimate concern of the state. What the state then demands is that any woman who has consensual sex must go to and report to the government and declare that this sexual act was consensual. This is the best way in which we can ensure that there is no coercion in sexual relationships. Now, imagine the Indian state or any state government demanding that. Our immediate response to that would be, this is completely disproportionate, because there are criminal laws that exist. What the state should really be doing is to make sure that whenever there is violence, the women are free and they feel safe to report violation, to report harassment, to report intimidation, right? Now, this is not the model which the states have adopted when it comes to religious conversion, whereas these are completely analogous situations. So if the state is worried that there is violence or intimidation or harassment, there are other less intrusive ways of achieving the same purpose. But what the state over here has done is it has made declaration requirements on all people, even at the risk of violation of right to privacy, by claiming that we want to ensure that there is no violence. This should completely reveal what the purpose of these laws is. The purpose of these laws is not to ensure that there is no intimidation and there's no harassment, because there are better ways and less intrusive, more civilized ways of ensuring that. Our IPC and CRPC is available there. The reason these laws exist is because they actually open other avenues of harassment and intimidation of somebody who wants to convert. If I want to convert from one religion to the other, and I'm forced either directly or indirectly to reveal to the world that I'm planning to convert or I'm considering conversion, that opens me up to tremendous amount of social pressure, potentially to vigilante violence, uh, arguably even for intervention by the state to stop me from converting from one religion to the other. And we've seen a number of examples of that, and hopefully we'll discuss them further. So this is the true impact of the violation of right to privacy. The impact of these laws is not the protection of religious exercise. It is not to make sure there is no force or violence, which is completely legitimate concern of the state. The real impact is violation of privacy, which then makes a person vulnerable to social and state violence and intimidation and harassment. Now, finally, I wanted to touch upon the last fundamental right, and then I'll wrap up. And this is the right against discrimination. And there are three fundamental rights that are relevant here. The first is Article 14, which we talked about already. Article 14 talks about equal protection of laws. Everybody is equal before the law and has the right of equal protection before the state. The second is right against discrimination, including religious, caste, etc., racial discrimination under Article 15. And even Article 25, which guarantees freedom of religion, also says that all citizens have the equal right to freedom of belief, freedom of religion, belief, practice, etc. So even Article 25 incorporates this element of non-discrimination and equality. In other words, our constitution is fundamentally based on equal respect and treatment of all persons, irrespective of their faith, and equal treatment of all persons' religious convictions. All religious convictions of persons should be equally treated, and there should not be any discrimination. Now, these laws violate these anti-discrimination provisions at least in two ways, and there could be many more, but two ways I can see very clearly. The first is that there are some states, for instance, the Arunachal Pradesh law, which is remarkable. But basically what it says is that it defines conversion in a way which covers only conversion to non-Hindu or non-indigenous religions. Many other laws say that those conversions where you're converting back to your original faith, whatever that may mean, is not covered under this act. In other words, there is a clear discrimination that is done under these laws between what would be considered Indic, arguably indigenous, arguably, or Hindu faith, and other faiths, specifically Islam and Christianity, I would imagine. And that's how I think the legal system or the police would interpret it. That if you're converting to Christianity, then these laws apply. But if you're converting, quote unquote, back to your original faith, then it does not. And that is the most clear-cut violation of all these non-discrimination provisions, especially the beginning of Article 25, which is everybody's equally has the right to practice their faith. The second way in which these laws are discriminatory is slightly more complicated, and but I think equally important. And this also proves why the 1968 Supreme Court judgment is completely off the beat, off tune with how India's constitutional jurisprudence has evolved. What the Indian Supreme Court has consistently held, especially over the last half a decade or 6 years, 7 years, is that just because the government or a legislation or a statute says that it is protecting a weaker group, it is protecting women, for instance, does not mean that it actually might be protecting women. Sometimes in the garb of claiming that the state is protecting women, it may be violating their rights. So for example, if in one famous case, if the legislation says that women are unsafe, therefore they will not be permitted to work in restaurants as workers in restaurants, as servers or whatever, in bars after 10 p.m. because we want to protect these women. The Supreme Court has held that these kind of laws are unconstitutional for being discriminatory. Why? Because even if the government is saying, or even if the parliament or state legislature is saying that we need these laws to protect women, they are weaker sections of our society, what you're actually doing is that you are violating their right to practice their livelihood, practice their freedom of movement, etc., by being patronizing, by stereotyping them as if they are weak people and they cannot make their own decisions. Now, this principle is, in constitutional law, is often called the anti-stereotyping principle, the principle that you are patronizing towards fellow citizens, treating them as people who do not have any freedom or any agency to decide their own life. And this is these kind of sort of rulings have particularly been accepted by the Supreme Court. Supreme Court, in, for instance, the recent Joseph Shine case is the adultery case, a very important case where basically the Supreme Court clearly held that when you are in the garb of protecting people, stereotyping subordinated communities or marginalized communities and taking away their autonomy, then you are actually discriminating against them. This is a violation of right to equality. And this is exactly what practically all these laws do. So whether the UP law or any other law, all these laws have heightened punishments when it comes to scheduled caste, scheduled tribe, and women. So if the allegation is that somebody is converting members of SC/ST or converting a woman, then there are tremendously higher punishments compared to others. Now, again, the ostensible justification which the state can give is that women, SCs, STs, these are vulnerable communities. They are weaker sections and backward classes as defined under the Constitution. And therefore, we want to specially protect them because they are vulnerable. But what actually these laws do is, as if anything I've said until now, this should be clear, that what the state is doing through these laws is not protecting them, but making sure that it is much harder for them to convert from one religion to the other, that it is much harder for them to exercise their religious choice, either by making them more vulnerable by violation of their right to privacy, or by making it much harder for them to get a sense of what are the available ideas in the marketplace of the spiritual world and spiritual ideas, so that they have a sense of what is going on, like everybody else should. So basically what these laws do is that in the garb of saying that they are protecting SCs, STs, and other vulnerable communities, they are making it harder for them. And on what ground? On the ground that not only are SCs, STs, women more vulnerable, but basically they are gullible. That basically they are incapable of making up their own minds about which religious identity or religious path or faith they should go for. And because they are so gullible and so innocent and childlike, that the state needs to come and have these tremendous punishments against anybody who goes and talks to them. This is stereotyping, this is patronizing, and this is a patent violation of what the Indian Supreme Court has called the Anti-Stereotyping Principle. This is a violation of Article 15. Again, in 1968, none of this existed in our constitutional jurisprudence. And perhaps Supreme Court can be forgiven for not having taken these things into account. But over the last 5 to 6 decades, our constitutional jurisprudence has evolved. Over the last 6 decades, we have also had the occasion of seeing how these laws are implemented on the ground and seeing how these laws actually have started broadening and becoming more and more pernicious, the perfect example being the UP law. And precisely on those grounds, there is a tremendous need to reconsider what the Supreme Court ruled in 1968. In my opinion, the 1968 opinion of the Supreme Court is wrong. Not only does it require reconsideration, it is wrong. Even at that time, in many ways, it was wrong. In my assessment, considering the violation of right to equality, anti-discrimination, right to privacy, freedom of religion, all these laws are absolutely unconstitutional. But the least we can say is that considering things have changed over the last 7 decades, the Supreme Court must sit on this matter again and consider the constitutionality of, of these laws and consider the correctness of its position in the Stanislaus case in 1968 again. So I'll stop here and very happy to take up more questions and develop more themes during the discussion.
Thank you, sir, for the thought-provoking address. Again, a reminder for the participants, whoever is willing to ask a question, whoever has any queries, please use the Q&A tab. The questions that are addressed there will be taken up in the last session of Q&A. Moving forward, I would like to introduce the next speaker. Advocate Siju Thomas is an advocate enrolled with the Bar Council of Delhi since 2013. He specializes in constitutional law and criminal law. He practices primarily on the writ and appellate side of the constitutional courts, including the Supreme Court of India. Siju is a part of the legal team which has challenged the various state anti-conversion laws. He earned his LLB from the Faculty of Law, University of Delhi, New Delhi. He is a fellow of the prestigious Blackstone program of Alliance Defending Freedom and has been an allied lawyer with ADF since 2017. Over to you, Siju.
Thanks so much, Lija. Hi, everyone. Thank you for joining this webinar and just staying on course with us. I think Mohsin has quite lucidly taken us through the Stanislaus judgment and really highlighted what are the various concerns for us when it comes to the judgment of the Supreme Court. It was a Constitution bench judgment. Any judgment from the Supreme Court, for that matter, is weighty. But when it comes from a minimum of 5 judges of the Supreme Court, then it carries extraordinary weight, and to repel it, to overrule it, would require, again, effort of that kind. My effort would be to cover a very short aspect of what was remaining, what was left from the Stanislaus judgment, and then maybe open the time for question and answers, for a discussion. I'm going to share my screen, so I'll request you all to bear with me for a moment. I hope this is visible to all. Under the Article 25 of the Constitution, which deals with the fundamental right to freedom of religion, there is a very important right that has been carved out that deals with your freedom to practice, profess, and propagate your faith. Now, I think what the Stanislaus judgment dealt with in much detail was the idea of propagation. And my endeavor would be, or the short question on which we'll be dealing right now would be, how the Supreme Court has identified or how it has interpreted propagation, and where I feel, or where even jurists, eminent jurists would feel the Supreme Court has gone off the mark. Now, as I was sharing earlier, the right to freedom of religion does include the important right to propagate, but how this right has to be interpreted has been open to much concern and also criticism. Now, one of the important questions that the Supreme Court framed when it was dealing with this judgment was that it framed this question in a way it asked us, is there a fundamental right to convert another person to one's own religion? Now, Mohsin did point out that the court was looking at the issue of religious conversions or looking at propagation as a right that is given under Article 25 from the point of view of the missionary or point of view of the proselytizer. But the way the court framed this question, I mean, in my view, this is a loaded question or a leading question. There can only be one way to answer this, and it would be no. There would not be a fundamental right to convert another person into your own religion. And I would say, I mean, as I go into my presentation, I go on to say that the Supreme Court did not appreciate the complexity of religious conversion as a process and took a very simplistic view of what this entails for a seeker, what this entails for a person who's looking for many options, who's looking for many views, or as Mohsin had pointed out, in the marketplace of ideas, in the marketplace of spiritual uh, viewpoints that are there, it did not appreciate what the process that a seeker would be going through when he's making, or he or she is making a choice of deciding which faith or which viewpoint to be settling on. I would go on to even say that Stanislaus is not only outdated for all the the jurisprudential development that has taken place, like the right to privacy not really being recognized by the court back then, 1977, when the Supreme Court sat on the Stanislaus judgment, but now it being a newer right. And similarly, the idea of autonomy, the idea of agency, and all these aspects which the Supreme Court has later dealt with in much detail. So for me, Stanislaus is not only outdated, but it is also bad law for having interpreted the concept of propagation or having interpreted the right to propagate in a very narrow view or sense. I would like to read out one paragraph from the judgment, which will help you understand and contextualize what I am exactly talking about. Now, the Supreme Court, in the Stanislaus judgment, goes on to say that we have no doubt that it is in this sense that the word propagate has been used in Article 25. For what the article grants is not the right to convert another person to one's own religion, but to transmit or spread one's religion by an exposition of its tenets. It has to be remembered that not merely to the followers of one particular religion, and that in turn postulates that there is no fundamental right to convert another person to one's own religion, because if a person purposely undertakes the conversion of another person to his religion, as distinguished from his effort to transmit or spread the tenets of his religion, that would impinge on the freedom of conscience guaranteed to all citizens of the country alike. So, in a nutshell, if I have to summarize this paragraph, what the Supreme Court has gone on to say is that as long as you're transmitting information, as long as you are sharing information, disclosing information from person to person, from place to place, disseminating, diffusing a statement, belief, or practice, it is all right. But when it comes to the penultimate decision of taking, or the ultimate decision of taking of actually making that jump, or making that, or taking that call whether I want to choose this religion over the other or this faith over the other, the Supreme Court is somehow saying that it is not part of Article 25, and it really boggles your mind as to how the Supreme Court did come to an understanding of propagation and also the process of religious conversion in itself. And in my mind, whenever I read this leading question that is there on your screen, or the loaded question, as I say, whenever I read this, it's a magician's image that comes to my mind. I'm sorry for this image, but this is what the Supreme Court is dealing with when it thinks that this is how conversions, religious conversions, happen in the country. That there will be some mumbo jumbo, there will be some waving of the wand, and all of a sudden you were in viewpoint, or you were in this faith or religion, and all of a sudden you have converted to some other point of view or to some other idea now that you carry. I don't think that is how conversion as a process takes place. And you are somewhere simplifying or in a way patronizing people who take these decisions, people who go through a spiritual journey to come to a decision of this kind. You are completely writing out the volition of that individual, the consent of that individual, or the agency that individual carries when he is hearing information from all sides, as you would do about any political party at a political rally, saying that, this is my manifesto, and these are all the various doles that we are going to be giving out. These are all the benefits that we are going to bring about for our country. These are all the various good things that I'm doing for my country. And at the end of the day, as a voter, as an 18 plus voter, or as a person who's above the age of 18, when you are given these choices in front of you, you are allowed or permitted that space to be able to take a decision. But when it comes to religion as a matter of choice, when it comes to choosing a faith, the Supreme Court, for mind-boggling reasons, had a very different interpretation of how religious conversions, how propagation, and how religious conversions happen. And when I use this analogy about magic, I am not really exaggerating. We have many pastors, we have many evangelists in the country who have been booked under the Drugs and Magic Remedies Act, essentially saying that the services or the ceremony that they perform construe magic in some way, where you are dulling the mind of the faithful or the people or the seekers who have come to your church service, your prayer service, and in the dullness of that moment, you are somehow making them take a decision about choosing someone's faith. This is patronizing, or this is considering the people who have that agency, who have that choice, to be like children, where they are I would say that interpretation of this form would really be looking down on an individual's right to be able to make choices, to make informed choices. But I wouldn't entirely say that it is entirely out of ignorance that the Supreme Court is coming to this interpretation. I mean, if you read the anti-conversion laws, if you have a chance, I mean, I'm sure that we are all being inundated with all this information that is coming through social media or through news channels about, the law being promulgated here, the law being promulgated in any other place, the most recent being in Karnataka. In fact, one of our challenges that we had, the cases that we had filed against the Karnataka ordinance, was listed today itself. And it cannot be disputed that the spirit of all these anti-conversion laws, as Mohsin had earlier pointed out, is to forbid all conversions. Even though the object of these laws, in and by themselves, they say that it is to keep a check or regulate forcible conversions. But I would go on to say that these laws want to forbid all conversions, and therefore removing or disassociating propagation and the act of religious conversion, which comes as a result of that propagation, where that person makes an informed choice. You, by removing that, you have somehow taken it out of Article 25, or taken it out of that important right that was provided when the Constitution framers had put together the Constitution and put together this important right. And I would say this because this is the intent of the anti-conversion laws, because every time, if you're following the newspapers, every time when this sort of a legislation comes to be tabled in the assembly of any state, or it is being considered by the cabinet in the case of an ordinance, there is always this violence that goes along with these laws. There is always this advocacy, this venomous rhetoric that we would not allow even one faithful from my fold, from our community fold, to go into any other fold. So there they're not talking about force or fraud or coercion that is being used. There you're talking about numbers. There you're talking about people who are in one group, people being taken from one community and being put into another community, or people being stolen by one community or the another. So it betrays the object of these anti-conversion laws, which they say is to check or punish forcible conversions. I would say the spirit of these laws is to forbid all kinds of conversions. Now, I would also say that Stanislaus is bad law, or the Stanislaus judgment is bad law for essentially not considering or failing to consider India's commitment to secularism. Now, I'm very careful when I use the word secularism because it's a highly contested topic, and there are very different brands and versions of secularism that are going about all around. But whichever brand or whichever version of secularism you agree with, I think we all could agree, even with a bare reading of the Constitution, that it did agree to an equal, to provide an equal treatment to all religions. That is to say that no one religion would be given prominence over the other, or will not be allowed to gain that sort of a prominence over the other. And this equal treatment is the reason that the proselytizing religions of Islam and Christianity were accommodated when Article 25 was being drafted. If you look at the Constituent Assembly debates that were being that dealt with Article 25, and when the idea of the concept of propagation, when it was being discussed whether it could be included into this article or not, this specifically came up. How do we provide equal treatment to these religions which have a fundamental element to their faith, where they need to share it with others, where they need to proselytize it with others, and if possible, if the other is persuaded through peaceful means, to be able to bring that person into the goodness of the faith that the faithful or the community enjoys. And it was quite fiercely discussed that this sort of an accommodation would be required for these proselytizing faiths of Islam or Christianity, so that we can accommodate them, provide them the space that they need to flourish. And this would be an equal treatment of these religions. And this would be a secular commitment of our nation if you put it in writing or in words like this. K. Munshi, one of the members of the assembly, went on to draw an important parallel between the constitutional ideal of secularism and also inclusion of the right of propagation, and then the corresponding right of religious corresponding process of religious conversions. He says that in a secular state, when he says secular state, it would mean a state which does not give one religion or one religious community credence over the other or precedence over the other. Everyone is equally balanced out. He goes on to say there is no particular advantage to a member of one community over another community in a secular state. There is no political advantage by adding more people into your fold, because we are not deciding politics, we are not deciding numbers, we are not deciding how the democracy would function or how the country has to be governed based on how many people are there in each group or each religious community. That is not how we are going to be deciding. And therefore he went on to say, therefore in that sense, the use of the word, inclusion of the word under a word propagate in Article 25 could not have any dangerous implications at all. I would say Stanislaus is bad law. Stanislaus' judgment is bad law because it disregarded this wisdom of the Constituent Assembly. It did not consider these aspects that the Constituent Assembly, in its own wisdom, after much debate, after much negotiation, felt need to be retained for India to be able to give equal treatment to all of its religions. And that, I think, the Supreme Court faltered at by not considering. Mohsin had quoted Sirvai. Sirvai is a celebrated jurist and a lawyer, and he seems to have understood or actually captured what is the process of conversion like. He goes on to say that to propagate religion is not to impart knowledge and to spread it more widely, like the Supreme Court would like us to believe when it framed that question. That, is there a fundamental right to convert another person into your faith? There is only a right to propagate. You only need to keep transmitting. You only need to keep sharing. Now, Sirvai goes on to say that, to propagate religion is not just that. That is only one facet of this important right. But it has to be able to produce intellectual and moral conviction in a person who's hearing that, who's processing that information. And that leads to action, which is what? The adoption of that religion. Successful propagation, according to him, would result in conversion. The Supreme Court never ever considered the complexity of this process. Never ever considered why is propagation as a right included in the constitution. It has to, your propagation, your transmission of your faith has to produce enough conviction in you to be able to, if you're persuaded so enough, you may take the decision that, after having considered all these viewpoints that had come before me, I come to this decision that, where I am good at where I am. I don't need to think about any other place. But if you are convicted, then, a necessary corollary of it, or a necessary byproduct of it, would be that, you go on to adopt that religion. And they use the word corollary, and that is what one of the important high courts, the Orissa High Court, went on to use when it the Orissa High Court went on to deal with it when it was dealing with the Ulata Height judgment. In Stanislaus before the Supreme Court, there were essentially two judgments that were there before the court to be decided upon. Two judgments that had traveled from one from Orissa and one from Madhya Pradesh. And from Orissa, the Orissa High Court had gone on to hold that the anti-conversion laws are unconstitutional and therefore cannot be justified, and therefore they need to be struck down. And the Madhya Pradesh High Court went on to uphold the Madhya Pradesh law, the Madhya Pradesh anti-conversion law, saying that there is no reason that it needs to be taken off. It is there only to check forcible conversions. And these two judgments together had traveled up to the Supreme Court. And in the Ulita Height judgment of the Orissa High Court, if you ever have a chance to read a court judgment, I would highly encourage you to read this judgment, because this is a judgment, even though the Supreme Court was sitting on top of it, the Supreme Court itself did not deal with the reasoning that the Orissa High Court had taken to uphold the to strike down, to strike down the anti-conversion law in Orissa. And in a sense, the a court in Orissa, the High Court in Orissa, goes on to say that conversion is corollary to propagation. It is, like Sirvai had pointed out, that it is a process through which, after having heard all the various viewpoints, you come to a decision whether I need to change my faith, whether I need to pick on a new religious idea or not. In fact, if you go through the judgment, it describes what the process of conversion is like. Now, the petitioners before the Orissa High Court were Catholics, and therefore they were able to present what the process of conversion within the Catholic Church was. And it describes in detail, there are paras dedicated to it, where it talks about how conversion would take place within the church. And it went on to say that religious instruction would be provided for maybe 6 months or up to a period of 1 year. Care is taken that the person, the seeker who has come to you, who wants to understand about your faith, understands has fully understood the tenets of your faith, and has come to a certain decision where he is now able to, or where the church or the clergy would consider whether this person is fit to be baptized. So there, the court does give credence to this idea that conversion is a process. It is not something that it's like a post office that, as soon as you receive your letter, and it is a magic act that has happened and that immediately results in conversion. The court did not entertain that idea. The court was able to appreciate the complexity of conversion as a process. And Stanislaus failed to consider the reasoning provided by the Orissa High Court. If you ever have a chance, I would highly recommend that you kindly go through it. So I would close very soon enough, but I have two important things to say. The Stanislaus judgment is bad law because it read down two things. First of all, it read down the right to propagate, as I've been trying to point out and as I've been trying to canvas through my presentation. It narrowed down the definition of propagation without considering what religious conversion is, which is in a way a byproduct or a corollary or a process that comes after propagation. By distancing both, it read down an important right within Article 25. It also read down India's understanding of secularism. The Constituent Assembly, or the framers of the Constitution, went to great lengths to negotiate the inclusion of this right in this article. And they really distinguish propagation from transmission. And this is quite clear if you go through the debates, if you ever have a chance to go through it. I had earlier quoted K. Munshi. Munshi had said that even if the word propagation was not included in the constitution, I quote him, he says, I'm sure under the freedom of speech, which the constitution guarantees, it will be open to any religious community to persuade other people to join your faith. You don't need the right of propagation to be included to be able to do that. Free speech allows that. You can share your faith, you can share the tenets of your faith with anyone if you like. So there is a reason that propagation, as the constituent assembly members, or as the constitution makers or framers understood it, why it was placed into this important article or an important right, that had not been appreciated by the Supreme Court, and I feel that it read down not only that important right, it also read down India's secular commitment also, as the Constituent Assembly understood it. One lawyer from the Madras High Court, one Mr. Surit Parthasarthi, has quite eloquently put it in one of the articles that he wrote for the Hindu, that, and I am quoting him, a conclusion that propagation ought to be restricted only to the edification of religious tenets is a reasoning that gratifies only the interests of the majority, and the majority alone, if that is the interpretation or that is the meaning that you want to give to propagation. This brings us back to the remark that I have made, and also Mohsin made many a times, that the spirit of all these anti-conversion laws is to forbid not just forcible conversions, but through its various ways, through its loose definitions, through its the cumbersome requirements that it keeps on all the seekers and the priests also. Why leave the priests out, or like why leave the clergy out? Why leave the pandit or the Maulana out? It puts these cumbersome requirements on them with one and only one aim, that is to forbid all conversions and not just forcible conversions. And therefore, it is extremely important at any point of time, whenever the Supreme Court has an occasion to reconsider these anti-conversion laws, or consider these newer anti-conversion laws or the amended anti-conversion laws, it has to reconsider the Stanislaus judgment also, because it will not only be dealing with aspects that are outdated now, or newer jurisprudential developments that have come in, but also the Supreme Court's own interpretation of the freedom to propagate, or the right to propagate, and the religious conversion that follows as a corollary or as a process. I think the Supreme Court needs to again consider that, and for that, I think Stanislaus needs to be overruled by the Supreme Court. Thank you everyone for a very patient listening. I would hand it back to Lija now to be able to moderate any questions that we may have for a discussion. Thank you so much.
Thank you, Siju, for all your wisdom and all the thoughts that you have provided for people to think about these sectors. Moving ahead, we'll be just discussing, I would be putting forth the questions that have come on board. Either of you can take it up and answer those. The first question would be, so two questions have been put together. First one, why has no Hindu or any other community not moved the courts for the right to exercise their choice of faith? This, when we see in the case of Presidential Order 1950. And the second question is, the RSS itself and a score of other Hindu groups have challenged the Christian and Muslim appeal that the Dalit converts should be given scheduled caste rights. This is the first part of the question. Do you want me to read the second part as well, and then open up the forum for you to answer, or
Lija, I didn't entirely follow what the question was there.
Okay.
If you can frame it also, that would be helpful for us.
Sure.
Yeah, should I respond, because I think this is John Dayal's question, and
okay.
Right.
So maybe I'll interpret it myself, and of course John can clarify if we have answered it. So I think there are two different related aspects, and both are extremely important. One is more political than the other, but legally as well. So let me just, on John's characteristically provocative question, why is it that no Hindu group has gone to the High Court or the Supreme Court? So one, I don't know. Maybe Siju has more information. Maybe they have gone, maybe they have not, I don't know. If I have to guess, I would say perhaps you're right that no Hindu group has gone, and there could be two interpretations of it. One generous, one slightly less generous. The generous interpretation could be um, that, and that is precisely what I think Siju was talking about. That is, there are different, and we need to appreciate that, and we need to perhaps accept that different religious traditions have different understanding of what propagation, proselytization, conversion, etc. mean. And Siju did point that out in his own presentation. There has been a fair bit of scholarship also and Constituent Assembly debates in many ways reflected that say for instance the Christian understanding, religious understanding of religious conversion is very different from how propagation has happened among many Hindu traditions, so-called Hindu traditions, where the idea is not to convert people, the idea is not a certain baptism, the idea is not about church, but it is about suggesting that certain kinds of religious practices may be adopted by others. So many Hindus historically have believed, not least of all, somebody like Gandhi, that in Hinduism, conversion is not even a thing. Right? All religious practices or religious identities in that sense have equal metaphysical value, and therefore conversion is something that does not have any resonance in the Hindu tradition. Now, that's what Gandhi said, but of course, there are many other proselytizing traditions within Hinduism. In fact, I'll I pasted my article on precisely this issue on in the chat box, and mostly, I'll be, I'm basing my assessment on the research I had done for that article. So the first element here is that we need to accept that different religious traditions have different competing understandings of what conversion is and whether conversion is required or not. And as you said, during the Constituent Assembly, particularly Christian groups are very adamant, legitimately so, that according to their understanding of their religious tradition, the act of proselytization peacefully is something that is part of their religious faith and therefore has to be recognized and accepted within the word propagation. Now, that is not something that most traditional mainstream Hindu traditions do. Right? Hindu, if that is our understanding of Hindu tradition, there's no active proselytizing activity that happens. So that's a generous interpretation. That the reason why they didn't challenge it simply is because they don't do proselytizing or missionary or that kind of propagation. They may do prachar, as we say in Hindi, but they do not do conversion activity or missionary activity in the same sense. A less generous interpretation would be that it is obvious to everybody that these laws are not meant to restrict ghar vapsi. They are not meant to restrict so-called quote unquote reconversion to Hinduism. Because the act of conversion to Hinduism, whatever form it may take, is not even in popular parlance described as conversion. It is, it is described as quote unquote reconversion, going back to your home, going back to your original fold. And that really clever and I would argue pernicious turn of phrase is precisely the discriminatory impact and social context of these laws. And had it been obvious that we are all equally placed, all religious communities are equally placed, or religious faiths are equally placed, then I think, John, what would have happened is that there would have been Hindu groups that would have also gone and said, we want to do ghar vapsi. Why are these laws? But it is a less generous reading would be that everybody knows that the state will not enforce it. The background of this ultimately is that Siju may have more data on it, but my impression is there are very few cases that actually go to the courts here. It's not really about interpreting these words by judicial authorities. What is really going on is that these laws provide a legal cover, an umbrella, for a large number of vigilante groups or extremist groups on the ground to harass and intimidate people. Right? So ultimately, the language of the law is deeply interconnected with the actual quote unquote implementation by non-state actors on the ground. That seems to me to be what is really going on. And therefore, if that is the reality of the law, then people who don't fear intimidation will not go to the court to challenge the law. It's only those people who will fear intimidation on the ground that they have a reason to appeal to rule of law and appeal to constitutional authorities to upturn that. And I think that did not come across very clearly in our joint presentations, but I would like to really flag that the social vigilante non-state violence and intimidation, which these laws not just permit but facilitate, is a fundamental constitutional problem with these laws. That is the problem of abuse and misuse of these laws. So these laws are fundamentally used because of their vague character and because how they are majoritarian in their larger historical institutional context, which Siju also talked about. That is fundamental to challenging their constitutionality. The second important issue, which is I think slightly disconnected but also obviously related, is Article 341 and Dalit Muslim, Dalit Christian sort of issue. I think constitutionally they are separate issues, because there the argument really revolves around, so for Christians or Muslims or Dalits who've converted to Christianity or Islam, they lose their scheduled caste status. And these issues before the Supreme Court ultimately will be decided based on both whether these the presidential order of 1950 religiously discriminates on the basis of religion against Christians and Muslims, and also about the meaning of the scheduled caste category itself. Right? Can a person continue to remain a scheduled caste person with that history of untouchability and stigma, even when they move from one community to the other? A related argument that has been made against that religious discrimination is that that is nothing but a state-sanctioned way of enforcing religious identity on people. You have created such incentives for people not to convert to Christianity and Islam among India's subordinated communities, specifically scheduled castes. And therefore, what is the difference between, on one hand, you're saying that, you want to restrict fraudulent conversions. On the other hand, you are using state power to make sure that people don't convert out of Hinduism, Buddhism, and Sikhism. And in my view, that is a relevant political point. Legally, they are separate sort of issues, but you're absolutely right that they are fundamentally connected, and they reveal the hypocrisy, an unfortunate hypocrisy of our legal system.
Thank you, sir. The next question is, what would be your take on the point that in the current political dispensation and environment, the clout of the Hindu NRIs internationally and the recent judgments of the Supreme Court, would it be foolhardy to challenge these laws in the court?
I think these laws are already under challenge. In fact, in many courts, the recent one being the Karnataka one, and we would like to believe, and we fully believe, I would say, that the courts would be persuaded by the letter of the constitution rather than by what is the popular opinion as such, or where the clout of other NRI groups was mentioned. And I wouldn't say that that would be the motivation, or a factor for the court to consider as such when these laws are being assailed or being challenged. It is the constitution which is to be interpreted when these acts are taken up before the various. In fact, it is pending before many of the high courts, and one from the Rajasthan, even though there is no such law in Rajasthan, there is a judgment by which the anti-conversion law is in force in Rajasthan, and that is now again pending before the Supreme Court. So these laws are already under challenge.
But if I may add just one corollary being the word Siju used, to what Siju said, which is, as he said, the Rajasthan High Court, on its own accord, I'm not even sure whether it was a suo moto decision or whatever it was, but on its own accord decided to introduce guidelines, if I'm not mistaken, which basically incorporate all these anti-conversion procedures in the state. And that should give us some maybe a moment of pause. It is true that judges have been not just upholding these laws, but in say, for example, in the case of Rajasthan, actually enforcing these laws all by themselves, even when the state assembly didn't do it. So nobody can underestimate the challenge of making this case before the judges. But as Siju said, one, these cases are already there. And secondly, we, as people who want to uphold constitutional morality in the spirit of constitutionalism and liberalism in this country, have whatever avenues we have to be activated.
Thank you, sir. The next question is, how can we say that the facts in Anuj Garg case are analogous to the punishment clause in anti-conversion law, since there is no violation of any of the women's rights per se?
Yeah, that's a good question, and I did cover part of that in my presentation, and I've obviously, again, most of my presentation is drawn from the article I've written, and I would sort of kindly refer you to that piece if you want the detail. But the summary version of it is that what is this? So for those who don't know, in the Anuj Garg case was the example I had given from my presentation, where what the Supreme Court held was that even when the state claims that it is providing protection to weaker groups, in that case it was women, against harassment, intimidation. In that case, it was restricting employment of women after a certain point of time at night in certain places. The court held that it was unconstitutional because, why? Because even when the state says it is protecting a weaker group, what it is fundamentally doing is it is being patronizing. It is stereotyping women as being fundamentally weak and incapable of making their own decision about their future, not to have freedom as a citizen and have the dignity to be treated as an equal with the same amount of maturity, mental, emotional, intellectual maturity to go about doing it. This is the same argument then ultimately which was accepted in the Joseph Schein case. The argument in the adultery case was that these laws are not unconstitutional because women are not being prosecuted under them, but men are. Right? So a man is being prosecuted for adultery for having sexual relations with a married woman, and the husband of that married woman can proceed against the man who's sleeping with his wife. Right? That is what adultery is, and therefore, actually, this is nothing to do with. We are not even prosecuting women. What did the Supreme Court say? The Supreme Court said, among other reasons, this law is unconstitutional because in all this business, how is the law treating the woman? The law is treating the woman as nothing but property of the husband, as somebody who does not have her own wishes, as somebody who does not have her own agency, right? And therefore, it's not the business of the government to intervene in these interpersonal relations, whatever our moral view of the problem of adultery may be. In my view, that is completely analogous to what is happening here. So, what is under these laws? There are heightened punishments for scheduled caste, scheduled tribe, and women, right? The people who are trying to convert them or whatever. Why? Right? That is the question you have to ask. Because whenever there is a classification made, there's an automatic Article 14 problem, right? There's a classification. There's a potential problem of discrimination. So the obvious question to ask is why? Why have you given more punishment to SCs, STs, and women? The government has to justify it. What could be the possible answer to that? The possible answer to that could be that SCs, STs, and women are weaker communities, therefore they require or deserve or need more protection, right? Then the question which Joseph Schein and Anuj Garg will ask us is why, right? Because what Anuj Garg has taught us is that you can't just stop at, okay, you want to give more protection, that's all right. You have to ask, why do they need more protection? Is it because they are genuinely vulnerable, like in SC/ST's Atrocities Act, or because you are being patronizing to them, that they are incapable of making their own decisions? My argument is that these laws fundamentally are not only restricting propagation, they are restricting the act of religious choice. If that is the case, then what these laws are doing is they are basically saying that if a person from SC/ST community wants to convert, we have to be really worried because these people are really gullible. They are incapable of making their moral choice themselves. That is what makes them gullible, and that is what makes them vulnerable. Not because they are exposed to violence, but because they are exposed to ideas. That is what makes these laws violative of anti-stereotyping principle under Anuj Garg and Joseph Schein.
Thank you, sir. Next question is a procedural question with respect to the anti-conversion laws, as in the procedure for conversion to Christianity, and what needs to be done, where it needs to be declared, and what is the rightful procedure under these laws.
So this varies from state to state. UP law was what Mohsin was referencing when during as part of his presentation. So there is a prior declaration that the convertee or the seeker, whoever wants to adopt a new faith, he needs to give a declaration of these many days to the DM concerned. And once the actual process is over, or the word used is the conversion ceremony, now even that is open to interpretation to a great extent. But I would say that if baptism is seen as if for Christians, if baptism is seen as a certain legitimate ceremony by which now you have openly professed that you have renounced this faith and now you belong to this faith, then therefore after the completion of that ceremony, then again giving an intimation to the DM concerned, and there are forms provided in the act which you have to be using. And post your conversion ceremony, you not only have to give an intimation, but you also have to personally appear before the DM concerned to satisfy that the conversion that was undertaken was legal and no unlawful means were used. Now this varies from state to state. Some the older laws have don't have these multiple forms of intimation. They would have you only give an intimation within these many days of the conversion ceremony or process itself. Gujarat law requires you to have a prior permission. It is one of the older laws that is there that required that even before you initiate the process, you need to take, and the word there used is that prior, that permission is to be required, not intimation per se. So it varies from state to state of how this law is applied if you have to legally and formally convert as far as conversion is concerned.
Thank you, Siju. This is the last question. Could there be some dialogue among different faith traditions and their representatives? Do you think this would help? How different traditions see the religion and how they can help bringing harmony between the religions? Since going courts, apart from going courts, if we can have a different interfaith talk where discussions are made, do you think that would help?
Well, I think I'm particularly ill qualified to answer that question. I am not a faithful and I'm not a member of any religious denomination. So, and I'm not a leader of any religious denomination, for better or for worse. So I can't really answer that. I'm sure as an ordinary citizen of this country who's unaffiliated to any religious institution, I'll be happy for the religious people and leaders to have a dialogue. I think that's a very healthy thing for any society. My only uh, my only sort of recommendation would be that we must think of this issue and look at these laws not primarily, and we may disagree about it, but this is more my assessment as a moral problem as well as a strategic issue, not primarily from the prism of religious denominations, not primarily as a problem for missionaries or for propagation. We should try and look at this problem both morally and strategically from the point of view of the individual religious person. And the reason for that is that for far too long, the debate around anti-conversion laws has been trapped in the lexicon and language and terminology of what is propagation, right? Is it propagation? Is it not? Proselytization, is it propagation or not? What is propagation? Is it spreading religious views or not, right? So the word propagation has hijacked, as Siju pointed out, the whole business around anti-conversion laws. And when we look at it from the perspective of propagation and missionaries, then we can believe that all these religious communities can sit down together and sort it out. What happens when we not look at it from the angle of propagation, but we start looking at it from the angle of an individual who wants to just pursue any religious spiritual path they want to do? But what is happening is that they are being forced, harassed, intimidated by religious groups, religious communities, political groups, etc. That shift towards the individual, I think, one clarifies this legal issue very, very obviously. The second it does is that it also strategically makes sense because we at least escape this problem of propagation, this obsession with propagation. Then we talk about religious freedom of the individual. Article 25 is not just propagation, right? It is also belief and practice. So what about we spend some time on belief and practice and not only propagation? And if that is the case, then my submission is it's not just the religious communities or religious leadership that has stake in this. It doesn't matter after a point of time what Catholic Church or Jamiat Ulama-e-Hind or Deobandis think about this matter. What matters is what an individual wants to do. And for that, we need to go back to the Constitution. That is the basis of our dialogue, and not only religious traditions.
Just a quick response to the query itself, that there is a lot of value in different faith groups coming together, especially like Mohsin had pointed out, that because of the vigilantism that is carried out, the non-state actors that are involved, I think for for good or bad reasons, faith is a very important integral element of for a citizen of this country, for an ordinary person, and therefore there is a certain level of influence that faith leaders would exercise over their communities. So to be able to talk reason in the polarizing environment that we are in, I think any person with influence or any community with influence, including faith groups, have a very important role to play at their own level. And there are very many aspects of looking at this thing. But to this pointed question, if there is value, I would say there is a great value if faith groups are able to unite and say that we disagree to the rhetoric or the hateful narrative that is going about, and we are able to talk reason and talk about that thing that brings us all together, the Constitution that we all agreed on. And then because of that, we are able to see eye to eye, and we can rise over the challenge that we are seeing in our country. So I think there is a lot of value, and we should constantly be looking for avenues to make that happen. And at ADF, we really do look for those opportunities, and in fact have really reached out to other faith groups and leaders to be able to help us or to speak into some of the situations that we have had. In fact, this comes to my mind that whenever we have seen a spike in violence and there aren't enough media groups, enough newspapers, or anyone prominently covering those aspects, we have had faith groups coming in, faith leaders coming in, and doing a fact finding there, and then talking quite clearly about what they are seeing on the ground, and speaking in one voice, speaking in a common voice. So that has been quite helpful for representative from the Hindu community, from the Muslim community, from the Christian community together to come and say, because often the extremists would maybe using or making references to one particular faith. But when you have this united front that comes and says that, we disown, the rhetoric that is going about with this violence, then, we are able to rise above the occasion. So we have found it quite helpful, and I would highly encourage all of you with, in that position of influence to be able to explore that.
Thank you, Siju. Thank you, sir, for your response to these questions. Before we conclude the webinar, an announcement for the participants. The recordings of the webinar will be uploaded on the ADF India YouTube channel soon for the benefit of all. We have not answered the questions which were not specifically related to the theme of this webinar. Hence, if you have any further questions, you can reach out to us at askme@adfindia.org. On that note, we are coming to the end of our webinar. I would like to thank our distinguished speakers, Professor Dr. Mohsin Alambat and Advocate Siju Thomas, for sharing their valuable time, leading such excellent discussions, and for all words of wisdom. We have 120 participants at the moment who have joined us for this webinar, and I would like to express our profound gratitude to each participant who took out their time to join us for this webinar. We hope you found this session meaningful and helpful. Thank you.
Thank you, everyone. Thank you so much.
Thank you. Thank you, Luja.
Thanks.